All right, peace and blessings. It's Friday, November the 24th, the year 2017. Monty Akers wrote me a letter, and I told him that he should write a letter to the world introducing himself and telling his story. And I sent him some examples of other people that have written their story, and this is the story of Monty Akers. So it's going to take a while to read it. If you would like to download it and read it yourself, you can go to yearofjubilee.com, go to list of other prisoners, and look on the files. And there's a file titled Monty Akers Life Story and CMU. All right, here we go. Its date of birth is February 24th, 1959, San Francisco, California. He wrote it on 11/3/2017. The title is Montgomery Carl Akers, maliciously prosecuted by a federal prosecutor in Kansas. I wanted to take the opportunity to tell my story to the world and those who might know me who read this address. I am writing this missive as I have been wrongfully maligned and said to have committed crimes against people that are both non-existent and the subject of a malicious prosecution in the process. Let me explain in the best chronological order the sequence of events that formed the basis of what happened to me. In 1997, I was convicted of 14 counts of bank fraud in federal court in Denver, Colorado. The reason for my conviction is that my ex-girlfriend, Lynn Derlin, testified for the prosecution at my trial, claiming she did not sign 15 checks that she had pre-signed for me to buy groceries at the grocery store and other related purchases during our relationship. Derlin cooperated with the prosecution in order to ensure that she would not be re-indicted after her indictment charging her as a co-conspirator in my case was dismissed. The funny thing is, the jury found me not guilty of one of the checks and found me guilty of the rest. That made no sense at all. Because I was out of money and no counsel, I was not able to challenge these matters with retained counsel. Instead, I was given court-appointed counsel who never raised the issue on appeal, and also the fact that there was evidence that was discovered that I did not forge the company checks I was claimed to have forged, which resulted in a separate conviction as well. I then began to try and amass the financing necessary to secure counsel and move on with my life. There was no law or prison rule against me doing so. In the process, the government utilized several snitch informants to infiltrate my life and gain information on what I was doing so that a plan could be hatched to subvert my ability to restart and have someone manage my business. In the process, I ran into a person by the name of Redacted and his daughter, Jennifer Roberts. Redacted is a known government cooperator and has testified against people such as Kenneth Glass, in the United States District of Colorado, and against me. His daughter, Jennifer Roberts, misappropriated over $50,000 from a person named Carla Guarino, Denver, Colorado, and tried to make it look like I was responsible. The truth is, agents of the Federal Bureau of Investigation, Federal Bureau of Prisons, used Redacted and Jennifer Roberts to orchestrate this scam. In the process, I was transferred to the Federal Correctional Institute, Florence, Colorado. Before my transfer, a snitch rat informant by the name of Redacted was placed in a cell, and I would soon occupy within a week or so. Let me just reply. Give me just a second. I'm so sorry. It's always something going on around here, man. It's always something. Okay, where was I? Before my transfer, a snitch rat informant by the name of Redacted was placed in a cell, and I would soon occupy within a week or so. Redacted worked as an informant for the Special Investigation Supervisor at the Federal Correctional Institute, Oxford, Wisconsin. Redacted was responsible for informing on a BOP staff member and several inmates for paying for sex with the staff member. The court records show that Redacted was upset with the fact that he was not able to purchase sex from the BOP staff member, so he informed on the staff member and all involved. As a result, he was placed in the special housing unit at Oxford FCI, where he got into more trouble stealing some of the Mexican inmates' tobacco, and when he was given the job as the orderly in the SHU, Redacted was then being handled by an SIS investigator by the name of Michael Moore. Moore had transferred Florence FCI in 1999, right before I arrived there. Once Redacted arrived there, he was put up to informing on me once I arrived in the Florence institution. It wasn't long before my private investigator at the time discovered who he is and what he was about. Redacted also became aware and went to his SIS handler and had me placed in the SHU and transferred to Oxford, Wisconsin. Once I arrived at Oxford, Wisconsin FCI in October 1999, I was greeted by Captain Moorhead and SIS Lieutenant Michael Moore. Both Captain Moorhead and Lieutenant Moore made it clear they were gunning for me over the Redacted incident. I told them, do what you got to do, so that made them even more zealous to put something nefarious together on me. Captain Moorhead was recently promoted from being the special investigative agent at United States Penitentiary, Leavenworth, Kansas. Moorhead was familiar with the FBI liaison, Agent Dennis Conway. After working with him for several years, Agent Conway, as it turned out, was the best friend of a federal prosecutor in the Kansas U.S. Attorney's Office by the name of Robin Fowler. AUSA Fowler's wife also worked as an AUSA in the Kansas City, Kansas office as well. Moorhead had me transferred on a bogus transfer to Leavenworth in May 2000 for the express purpose of trying to put a case on me, which means to put criminal charges on me at all cost. Within 1 month, I was placed in the SHU under investigation for what the prison system purported to be bank fraud charges. Moorhead Agent Conway used another Leavenworth prison lieutenant by the name of Mercer Patterson Jr. to orchestrate the criminal charges against me. I spent the June 2000 to September 19, 2001 in the SHU at Leavenworth under investigation. My girlfriend at the time hired a Kansas City lawyer to straighten out what the problem was here. In the end, I found that this case was assigned to AUSA Kim M. Berger, also known as Kim Fowler. The lawyer contacted Kim Berger to find out what the status was on this case. Kim Berger claimed that she hadn't decided what she was going to do, but if she was going to the grand jury and seek an indictment, it would be in September 2001. That was the last I heard these charges when no indictment was returned in September 2001. In September 2001, I was transferred to the ADX Max Penitentiary in Florence, Colorado. I stayed there until June 2004 when I thought I was being released. Instead, I was charged with 5 counts of wire fraud and taken back to Kansas to face these charges. My wife tried to assist in every way possible to bring closure to whatever it is that I supposedly did. She tried to help me gather information that showed I committed no crimes. Each time I tried to hire an attorney, Kim Berger, and the FBI agent, information that showed I committed no crimes. Each time I tried to hire a retained attorney, Kim Berger, and the FBI agent, James Kasai, would create and manufacture some sort of interference. As a result, I could not hire a retained lawyer. I was forced to take court-appointed counsels who were handpicked by the Kim Berger. When I complained about the representation that I was being given, the judge on my case, Catherine H. Verratel, would team up against me with AUSA Berger and claim that I was crying foul and that the representation I was given was the best that could be afforded me, which was completely untrue. Berger made sure that the court-appointed counsels did her bidding, and that was to try to get me to plead guilty so she could justify all the illegalities that she had inflicted upon me to that point. Berger also used Agent Kazai to contact anyone and everyone who I had contact with and indirectly threaten them that if they assisted me, they would be standing right next to me as a defendant. Against these odds, it was impossible to obtain any sort of help with my case, and the prosecutor knew it. Next, their tactic was to try and destroy my relationship with my wife and the friends closest to me, who were not going for this oppression. In order to solidify their plan, a former counsel on my case in the early going was enlisted to become my counsel when I fired my last court-appointed counsel by the name of Jacqueline Ellen Rokusek. Rokusek convinced me that I had indeed committed a crime by doing business over the phone at the Corrections Corporation of America, and that the jury would find me guilty of this charge. Rokusek was giving me bad advice, and I had not committed any crime. By this time, my wife was out of money, who had to move back to Germany just to survive on social welfare, as she was sick at the time because of all that had happened to me because of acute stress. Next page. My wife, Graysna Schultz, was sick due to all the stress that had been placed on our relationship, and as a result of the prosecution's never-ending desire to harm my ability to provide for her and my family at the time, she moved back home to Germany so that she could avail herself of the social welfare and medical treatment. Graysna was in the United States studying for her PhD in psychology, which she obtained in 2001. Rokusek was working with Kim Berger, the prosecutor, to get me to plead guilty to some kind of charge so they could get me to sign what is called a plea waiver that basically allow the government to say whatever they want or whatever they want about you, or do whatever they want, and you cannot defend yourself against any of their actions. That's what that device is used for in layman's terms. The courts claim a plea waiver is used to minimize government expense for guilty persons, and the waiver brings finality to your case. The plea waiver issue is now the subject of misuse, as was done in my case. Rokusek was paid under the table for getting me to accept a plea and waiver for court-appointed cases she would be assigned in the future. Rokusek, like many lawyers, make a living on court-appointed cases. These lawyers, if you can call them that, go to special classes to take court-appointed cases. In essence, what they do is to agree to do the prosecution's bidding and the judge's rubber stamp. What it is the prosecutors do in conjunction with the court-appointed lawyers. What ends up happening is you have these lawyers like Rokusek who make a living off of court-appointed cases. I was Rokusek's first court-appointed case after she left my case in 2005. Rokusek lied the entire time of my representation about her role in being an assistant U.S. attorney on my case in the early going. My judge, Catherine Veratel, the case agent, James Kazai, and every court-appointed lawyer I had knew Rokusek was a prosecutor on my case in the beginning. Each one of these so-called great attorneys I had were all doing the bidding of Kim Berger. They did so because they make their living off of all the court-appointed cases that will be recommended to them by Kim Berger, who works behind the scenes with district judges to have assigned cases to these lawyers specifically. Rokusek knew I did not commit a crime. Yes, I did not use good judgment in the way I employ people to carry out my business, that is true, but it was not my intention to commit crimes and defraud banks any longer. The problem here was that I had a track record. It was easy for the prosecution to pin criminal acts on me that had similarity to crimes I was convicted of in the past. My criminal record was not what they made it out to be, but when you have a lawyer, Rokusek and the other court-appointed lawyers I had, working with the prosecution to create a backdrop of criminal conduct, it is easy to do. Rokusek conned me into pleading guilty, and that if I did, she was going to fight with every ounce of her being to make sure I was only convicted of what I really did, not what the government was trying to inflate concerning my conduct. Rokusek knew this Kim Berger is a sadist and a real ugly human being. She knew that this Kim Berger has changed her first, middle, and last name over 5 times in the last 10 years up to that point. Rokusek had no intention of bringing truth to my case. Her only intention was serving Berger and my judge and doing whatever would be necessary to destroy my life and my wife's life in the process. This is how mean and ugly these people are. They should know why I think about them the way I do. What happened next was within 1 month I was able to contact a Las Vegas, Nevada lawyer and determine that Rokusek gave me bad advice and that my actions were not criminal. I then went about trying to withdraw my plea. Judge Veratel would not allow me to withdraw my plea and now implemented the next phase of how they were going to keep this wrongful conviction intact. Thereafter, I filed several pro se motions to withdraw my plea and fire Rokusek. Judge Veratel convened a meeting outside of my presence with Berger and Rokusek to plan a strategy as to how they were going to handle this situation. It was agreed that Rokusek, not AUSA Berger, would file a motion to have me sent for a mental evaluation to see if I was fit to assist my attorney during the proceedings. A hearing was held in December 2005, which was a sham by Judge Veratel, and Rokusek made it look like I was firing lawyers because I am mentally ill and not recognizing what is being done for me. Rokusek is a real piece of work. I can't stress what it is I could say right here about her. I was sent off to be mentally evaluated. When I was interviewed by the psychologist evaluating me, she just looked at me and shook her head. She asked, "What are you doing here?" as she read my file. I explained my story. She said that she would do some more tests, but from what she has determined, next page, there was nothing wrong with me. Thereafter, I was put through a series of tests and provided information for people who knew me to be contacts on the outside. When the responses came back favorable for me, my prosecutor was informed of the same. Berger then contacted the psychologist performing the study and tried to influence her to find a set of facts that determined that I was mentally ill and could not assist in my defense. Rokusek also contacted the psychologist and did the same thing. The psychologist did not like being bullied by these people, Berger and Rokusek, and told me about what had happened. She then gave me a statement to use in court if needs be as to what had transpired here. When this plan failed by Rokusek, Berger, and my judge, they tried to play the whole thing off and not even discuss the mental health evaluation, other than to say there's nothing wrong with him at my sentencing. As a forethought, I originally agreed to plead guilty to a 37-month sentence because my wife was sick. I explained to the lawyer I had at the time, Michael Harris, a federal public pretender, that I would only plead guilty if what I am making a deal for is what I'm going to get. I couldn't put my wife through any more of this hell. In cowardly fashion, Berger went back into her bag of tricks. She tried to use this Mike Harris guy as a shield in order to implement the ruse she was trying to involve me in. Berger knew all along I had committed no crimes and that she was in cahoots with Judge Vraytrell to contact and sentence me to a prison because of their hateful animus toward me. Judge Vraytrell was upset with me because I was a jailhouse lawyer who assisted a person that went before her with filing his own papers, and she had to let him out because upon governmental misconduct in his case. Berger knew this and had illegal and impermissive what are known as ex parte communications with Judge Vraytrell before they ever decided to indictment and have my case assigned to Judge Vraytrell so she could provide the ability to railroad me in the courts. Once I was sentenced, Judge Vraytrell, Rokusek, and the probation officer Michael Arbor and Berger were all in lockstep with each other on how to make sure I was wrongfully convicted and how I would serve my sentence. At sentencing, the rules of the court are different. The prosecution ended up putting on witnesses that had nothing to do with any crime I allegedly committed. Rokusek, working for the government, could not help herself to question the case agent and witnesses and say this is just going too far. Rokusek couldn't even believe the level of BS that was being testified to in the court here. Rokusek did not call any witnesses on my behalf, even though my wife friends wanted to testify. I was allowed to read the letter from my wife, which Judge Vraytrell gave no consideration whatsoever. The government witnesses could substantiate no criminal conduct on my part. Even the witness-in-chief, Anita Jenkins, was perjuring herself on the stand and saying she received a power of attorney from me, which even Rokusek pointed out during cross-examination was not my signature, and there was no way I could have sent it to her the way she the way she claimed. I lost my spot. Okay, Jenkins was found to be lying during most of her testimony. The testimony was coached by Kim Berger, the same as all the other witnesses, including this drag by the name of Donald Mixon. Berger used Mixon to stage criminal activity along with the case agent James Kazai, having to do with drugs and forgeries when I had no contact with him or Mixon's cohorts, and the government knew that. Nonetheless, they tried to pin this conduct me at sentencing, not a separate criminal indictment. They knew if they indicted me, they would lose their jobs and go to jail for the conduct. I was sentenced to 327 months because Judge Vraytrell claimed that I had admitted conduct against a financial institution which carries a maximum penalty of 30 years. The most I could have received under the law, if properly applied, was 5 years. Now I'm back in court on all this mess. Judge Vraytrell knew that my conduct did not affect a financial institution. She had me sent to ADX maximum prison to ensure I could not gain a proper appeal on all that transpired here. I was given a court-appointed lawyer on direct appeal who was handpicked by Kim Berger to not put my issues before the Court of Appeals. I have been fighting ever since. Now these people have a day with justice. I have all the goods on the people who were involved in exactly what they did. I have committed no crimes against a man with multiple sclerosis. Tony Casanova was my friend. He sent a letter testifying that the prosecution was to blame for all this. Berger put his son, James Casanova, on the stand to try and say he has some knowledge of my wrongdoing. James Casanova, being the coward cretin that he is, could not supply any testimony other than to say he didn't like me. In the end, the same happened with the case agent, James Kazai. Kazai could not supply any witness testimony of my further criminal involvement or commission of any crimes after I took my plea in this case. Next page. Kazai could not substantiate one iota of criminal conduct on my part. Where I'm at today is I'm back in the U.S. Court of Appeals for the 10th Circuit in case number 17-3146, United States v. Akers. At this time, I am appealing the recent judgment in my criminal case in Kansas, case number 04-289-KHV-1, whereby I have alleged that I have new discovered evidence that conclusively shows that AUSA Kim I. Berger Martin Flanagan, whatever her name is, confiscated without a warrant 2 checks totaling over $25,000 from the U.S. mail at judge-confiscated direction. The very same issues were brought originally in my appeal back in 2009. At that time, the court concocted a scheme to deny my ability to bring these issues to light. First, Judge Vratrell claimed that my newly discovered evidence of stolen checks from the mail was too far removed from my original issues on appeal. What a joke. I had just found out about these issues less than 2 weeks before I filed my motion to amend my S.2255 motion with a sworn statement of AUSA Berger Martin that Judge Vratrell was a part of a collusion to confiscate my legal negotiable instruments from the mail before this case began, with which Berger and Vratrell lied about throughout the entire proceedings in open court, only to have Berger admit this conduct in a sworn affidavit in June 2009. Judge Vratrell made a ruling I did not timely file my motion for consideration, as the motion was specifically directed against her and AUSA Berger. When I appealed to the U.S. Court of Appeals for the 10th Circuit on this matter, the 10th Circuit concocted a ruling claiming that I did not file a timely notice of appeal. I have been fighting these rulings on other grounds ever since. In December 2016, a package was mailed to a longtime friend of mine in Arizona containing 2 checks and paperwork associated with my criminal case. It was sent anonymously, even though the sender had a tracking number that turned out to belong to the Correctional Corporation of America Leavenworth Detention Center in Leavenworth, Kansas. Inside the envelopes with the 2 checks was a post-it note saying approved KHV. KHV stands for Catherine H. Vitrail. Now, I then made a motion in the District Court of Kansas to remove Judge Vitrail from the case and to reopen my 2255 proceedings based on the fraud being perpetrated upon the court by Judge Vitrail. Once again, Judge Vitrail sidestepped the issues of my motion, claiming that she has ruled on the same prior proceedings which she had not. We then had further investigation and found that back in August 2016, a huge scheme was uncovered in the District of Kansas involving Assistant U.S. Attorney Kim Berger, Martin Flanagan, and Jacqueline E. Rokusek, and other federal actors in the District of Kansas. The case is now being investigated by U.S. District Judge Julie Robinson. As to the Flanagan and Rokusek, Aaron Tomasek, and others, Rokusek is believed to be a good girl in this mix. Further investigation is revealing that there has been a long-standing criminal enterprise at work here involving principally Kim I. Flanagan and many other federal government actors and detention center personnel. It is also coming to light that many attorneys knew about this as well, including Rokusek. The depth of this criminality is only now at the surface. I am digging into this with a shovel in each hand, and each and every person who is involved and who has ever been involved will be held accountable under the law. Many attorneys are now investigating the thefts of mail, recorded conversations, illegal, etc. related to this discovery. Please look this case up online. United States v. Black, case number 16-20032-JAR, U.S. District Court, Kansas. What the case in United States v. Black uncovered was a long-standing criminal cooperation between judges, prosecutors, and certain criminal defense attorneys to record, monitor, and confiscate prisoners' mail property while they were housed at the Corrections Corporation of America Leavenworth Detention Center. I had informed Judge Vratrell that this was happening to me back in 2004, and she, Flanagan, Rokusek, and others denied the same in my open court proceedings. Now this conduct has come to light in a big way in the Black case. This is criminal conduct at the highest level in the judiciary of the federal courts in Kansas. The public must get involved to ensure that the proper investigation is undertaken in this matter. All right, this will be uploaded to yearofjubilee.com. Go to list of other prisoners. Look for Monty Akers' story. Thank you.